I said, what I'm going to do next is I'm going to have them sign these judgments. And I showed them the two judgments I wanted them to sign. I said, now I'm going to send them down to the clerk's office, and I want the clerk to sign it that it was a default judgment. And I just want them to deliver it back to me in 72 hours. And I said to them, if they don't do that, then I'm going to say to the district court or the United States District Court, are you a public officer or are you a public employee or are you working for a private corporation and you're just a legal instrumentality to the person known as the United States? Then you don't have to be bonded. So, just like the IRS doesn't have to be bonded. They're not bonded public employees. They're not bonded public officials. So if I'm trying to go after their public oaths or I'm going after their bonds, they don't exist. So I'd be wasting my time. So I said to the Marshal Service, I said, you're going to get a complaint again from the district court down there that I'm asking them for their public oaths to be, put on a public record that I have access to them, and then I'm going to ask them for bond information. And they're going to tell you that I'm committing paper terrorism. I said, I'm not doing that. I said, this is your law. This is their law. I'm doing it step by step by step. And I showed them all the steps that I'm still going to do. Mm-hmm. So, like, the Marshal guys were looking at the steps. Thank God that, like I said, the Marshal guys was like, then you're going to do, I said, this is the book I got it from. I got it from your website. I got it from the uscourt.gov website. I said, you see that on the very first page of uscourt.gov website, what does it say? All federal courts are Article 3 courts established under the Constitution.
And courts of record.
Well, that's what it says. I said right there. I said, well, let's first juris section 344 says all federal courts are courts of record.
Well, and then I thought it said that on that website too.
No, well, what I said on the website too, it said all state courts are common law courts. That's what it says on that website. The website I posted for you guys. So the first thing it says is federal courts are all federal courts are Article 3 courts. Established under the Constitution, and it says all state courts are common law courts. And then I said to them, if you look at Chorus Juris, not Chorus Juris Secundum, Chorus Juris, the first one, it says the characteristic of a federal court. Characteristic, all federal courts are courts of record. And then I said to him, let's look at Black's Dictionary. What's a court of record? Only moves under the common law. There you go. Only moves under the common law. So I'm moving into federal court, which is a court of record, and all courts of record are under the common law. I said, and I showed him a map. I just sent it to Tom Murphy and somebody named Greg Grupa from Chicago. I showed him a world map that there's only 5 countries left on the planet that common law is the predominant law of the land. It's United States, Canada, Ecuador, India, and Australia. Everybody else is civil. So when anybody tries to attack me, I said, under the civil code, I just drop the map on the desk and say, what does that say? The common law is only in America, Canada. That's actually a picture of it. It's all in colors, and it looks pretty. And I said, so I'm moving this. I have the authority, the control, the jurisdiction to move it over to the common law side. This is going to now be a common law claim. No more administrative complaints. Now I'm moving right over to the common law. And how can I do it? Look, uscourts.gov clearly says all federal courts are Article 3 courts. So when I hear a lot of these free men in Montana screaming up and down on the radio, I said that to the U.S. Marshal guys. I said, look, I apologize. Back in 2003 to probably about 2008, I was just as crazy as these free men were using all this, there's no such thing as Article 3 courts anymore, and I got to sign everything like Isaiah or son of Ezekiel and free man and flesh and blood. I said, all my lawsuits are 1 page long now. I said, scary. I said, they read the whole lawsuit in like 10 seconds. They're like, that's it? That's your whole I said, my whole lawsuit. They go, are you kidding me? I said, no. Does this sound like anything threatening on there? Like, no. It's 1 sentence. I was like, I described me. I described the defendant. Like me, it was like maybe 2-3 sentences. The defendant was 2-3 sentences maybe. The claim was, jurisdiction was simple. There's a diversity of the party. The parties are diverse. And the amount of controversy is more than $20. And the next line was the actual declaration of the wrong was forgery. They uttered a forged insurance, which is interfering with my rights. And then order that I put at the bottom is that I order, immediate compensation of whatever, $1 for every second my rights were interfered with, and that the other judgment was going to be signed that there is a forgery and that the forged instrument is to be noticed by the world as a void document, a void instrument. So I said, that's it. I said, it's simple. I said, how hard is that for you guys to read? I said, look at the front cover. What does it say? Like Karl Lenz versus like this, like DHL, it's like CPS for everybody else around the world. I said, what does it say on the other side? It says what the cause of action side says. It says trespass, colon, and then it says what? Forgery, and what does it say at the bottom? Verified. That's it. What does it say underneath there? Trial by jury, and magistrate only, and I'm trying to remember. It said one more thing on there. Trial by jury, you always want to say. You don't want a jury trial. There's a huge difference between jury trial and trial by jury. And then you want to make sure that you have magistrate only, court of record, magistrate only, and that way and everybody knows Billy Thornton's thing is like the 4 elements of a common law court of record. Court of record moves under the common law, can hold people for contempt. The magistrate is independent of the tribunal. And what's the 4th one there? Oh, keeps a perpetual record of the proceedings.
Right.
Perpetuity and a seal.
Right. Go ahead.
No, so my lawsuit is incredibly simple. It's 1-page long. So when I say these poor guys, stop writing these 2-page lawsuits, 3-page lawsuits, 500-page lawsuits. I said to the marshal guy, I says, look, I was guilty of that. In 2003, I wrote like a 300-page lawsuit. My sister was standing right there. I said, you remember writing that nonsense with me, don't you? And she said, yeah. And then I said, I thought I trimmed it down like 5 years ago to 100 pages. Now I'm down to 1. I said, I make my claim. Now, somebody has to come into the other side who's a man who's going to say that my claim is not true. Good luck with that. I
think part of the problem is here when we have an administrative agency that's bringing a claim against you, that is a civil equity legislative Article I court. And so here we're taking and using a civil legislative form in pleadings demanding a court of record. Well, they're giving you an equity legislative court of record. It's just not a common law court of record, and I believe it's the form of the pleadings that makes them unintelligible to the court because they're not in proper form and substance like what you're suggesting that you did with your suit. But, of course, the question would be, can you, with a simple answer in a common law court of record form and substance, convert that action over? And it should be because you were never subject to the original act to begin with because it only had application to a contract or an artificial entity.
Right. And like I said, it's very simple. Like I said, when me and my sister were waiting in the marshal's office and they pop out, I thought I was actually going to go to jail. I thought I'd never come back to see any of these animals or this farm ever again. I really did. I said, if you guys, because I figured they were a little nervous because I'm beyond too simple. And my stuff is so amazing, like so simple, it's scary. So what was funny is I said to my sister, I couldn't imagine that poor magistrate who's going to try to arraign me. Oh, my God. They're going to have me like sitting in some federal prison for 100 years waiting to get a contract over me because
Wait a minute. Why would they be trying to arraign you? Did they file some type of claim against you for filing your suit?
Well, what I'm saying is I pitied the fool if they did try to charge me with a crime like Title 18 because how in the world are they going to get me to contract with the court? I'm going to say, may I have a piece of paper and a writing utensil, please? Because I only answered court in writing. And I would have made some very simple thing. I would have said, what is the nature of the person whom this court seeks? And they would have had a coronary. Because nature is defined by God. So God defined me as a man. So as soon as they say that there's a man present in court, they're realizing they're a judge or they're just simply a magistrate. They have no jurisdiction over a man. And I'm going to say now, if you recognize there's a man in court, good. This is a common law land, right? Good. This is my wish to move this matter over to the common law. I said, if we're in England or France, and I actually did that to this marshal guys. I said, see this map of the world? I said, you see everything else is blue. Over here we're orange. I said, now if we were in France, I'd be screwed because the civil law is what I'd have to answer to, and I'm guilty, and I have to prove myself innocent. Thank God we live over here. You see where I colored it orange? I said, this is common law. They have to prove their case against me, and they can't make a claim. The only thing the government could do is make a complaint. They can't make a claim because only man can make a claim. The government can only make a criminal complaint. They can't make a criminal claim. So I hear all these guys saying, oh, we're going to make a civil complaint. You guys are crazy because that's what governments do. You're dropping your status. When you go to a complaint, you're dropping your status down from a man to a fiction in law because a complaint is done by, like, government entities. Governments can't make a claim. They don't. You never heard of such a thing as, well, there's a criminal claim against me. There's a criminal complaint, been issued against you.
Well, but it depends on what type of remedy you're seeking. There are legislative equity statutory claims that you could make if you understood them. So it just depends on what option you want to take, really.
I want the one-page option, the two-sentence option. I just want to state my claim, make my claim, and say, is there any man going to come forth to say that my claim is not true? Does anybody else have a superior claim than me? If not, the government can't make it.
And then that's the whole question on dealing with these administrative agencies when they're coming after you. If they don't have an original contract that you sign into knowingly, intentionally, and voluntarily to receive a consideration with full disclosure, then who is the real party of interest that was injured that filed the complaint, a verified complaint against you? So you've got them either way.
Even, like I said, even if it's a verified complaint, that's silly. You'd want to make a verified claim against me.
No, I'm talking when they're coming against you, not when you're coming against them.
Even if you enter into a contract with a fiction, like say you made a contract with your television for some reason, I don't know, you could pop yourself out of the contract. Like I said, maybe you heard that explanation I gave one time. What happened if you and I were on an airplane, and we're in Al Jazeera Airlines or El Tel Aviv Airlines, and we're flying over to Israel, and all of a sudden some crazy Palestinians get up and say, everybody who's a U.S. citizen, come forward so we can slice your throat right off the plane. Now, are you going to exercise your right to be a U.S. citizen and say, oh, well, they asked me if I'm a U.S. citizen. Yeah, I guess I'm a U.S. citizen because I got a Social Security card. Yeah, I guess I'm going to get my throat slit and thrown out the plane. No, you have the right to exercise. It's a right that you could exercise, just like you could exercise your left hand or right hand if you want to. You don't always have to be a U.S. citizen. You don't always have to exercise your left hand or your right hand. It's a right that you may choose to exercise when you feel it's at your convenience or your benefit. Now, if I'm not going to get a benefit by being a U.S. citizen at this particular moment in time, how is they going to prove in court that I'm a U.S. citizen? Good luck with that. Who's going to stand on the other side and testify as a fact that I'm a U.S. citizen? An attorney can't testify in court. And Clayton Cherry taught me this, because if you look into Google, there has been no New York State foreclosures on homes for like the last 3 or 4 years, because these guys, like a Clayton Cherry, said in court, we're going to need to have the representative of the bank take an oath to testify in open court on the witness stand that everything he's saying is true, or it can't be entered into the record. There has been no foreclosures in New York State for like the last 3 or 4 years, because the Supreme Court judge in New York said he's absolutely right, or his little group is absolutely right. An attorney can't testify to a fact. He has no first-hand knowledge of any of the events that happen.
Well, they brought the bank president and manager here on a case of my friend and did just that.
They took the stand, and they testified under oath of affirmation that they witnessed the closure, the signature, the mortgage, everything, that all the paperwork has been in their possession at all times.
Well, I don't know what all the questions were, but yes, they led them to that testimony, you bet.
Well, like I said, what Clayton Cherry did was great. The way the man explained it, I would explain to a lot of people, it's the first thing you ask a judge is, it says, is it true that for evidence to be, and facts to be noticed by the court, it has to be come in on first-hand witness, and that both parties must be sworn in? And he's like, yes, that's true. He's like, okay. Well, for an appeal purposes, may all the evidence or notices or facts to be entered into court, can we please put it on the record under a sworn oath of affirmation? And the judge will say, well, absolutely. He says, okay, well then, I would like to swear on the oath of affirmation that everything I'm saying is true and nothing but the truth, and help me God. Now, I want the other side to swear themselves in. And then he's like, the attorneys can't do that. It's like, well, then who's going to swear in for the other side? Well, then nobody's showing up on the other side, so I guess I win by default. He says, so that's how you knock the attorneys right out. My sister did it in her divorce. And like I said, she told some other man today, she said, you know what, that was the first case I ever went into court, and I won. She said, I've been doing worse and worse and worse as time has gone by because I didn't know anything. And the first time I went to court, I just listened to my brother, and I did it exactly the way he told me to do it. She says, now I'm trying to figure out a way to make it better, what he tells me, and I'm just starting to lose now because I just won't stick to, when she appeared in court, the judge lady, they're all called Supreme Courts when you go to divorces up there in New York, she said the Supreme Court lady said to her, it's time to introduce the parties. She said, who are you? She said, well, my name is Karen, and I moved in my person. I and my case are now before the court. So then she said, okay, you're going to be represented by attorney. She says, my name is Karen Garner. I and my case are now present in court. And she says, so are you going to self-represent or do you want an attorney appoint you? She says, I am Karen Garner. I and my case are now present in court. And the judge said, okay, I understand. So then they introduced the other side, and, her husband was like a rich guy. He's got a quarry, he's got a scuba shop in Long Island, he's got a ranch in Montana, he's got big bucks. He had 3 attorneys. And they all introduced themselves. So my sister was the moving party, so she went first. So the judge let her say her thing. And as soon as the other side stood up, the ex-husband was smart, got a female attorney because it looks better, a female attorney going against a woman and a male attorney going against a woman in a divorce. As soon as the female spoke, my sister said, I object. And the judge was like, "Why was your turn to speak? Now it's their turn to speak. Didn't my husband did he get a sex change? Because it sounds like there's a woman talking over there." And she's like, "No, that's his attorney." He's like, "Ma'am, are attorneys allowed to testify?" And she said, if she has any first-hand knowledge, she has. Can you ask her if she has any first-hand knowledge of this? He says, "Do you have any first-hand knowledge of this, to any events that occurred during their marriage together as husband and wife?" She's like, "No." He said, "Then I object to this woman speaking on anything in this matter, and I demand that she is not be recognized by the court, nor any facts or evidence that she's bringing into the court can be taken notice by the court." And the judge said, "Okay, duly noted." She said to the attorney, she said, "Sit down." The attorney started to say, "But ma'am," she said, "you know the rules, now sit down and shut up." So then her husband had to get on the witness stand, and she just beat him like a piñata because he didn't know when to shut up. He just started talking, and she said, "I cleaned his clock." And I'm telling you, that's all you have to do. When the judge realizes, and you just say to the judge the nature of the person that's before the court, the judge is competent. It's when you start to try to get away from other than just saying, "My name is," what's your name, sir? "My name is Karl Lenz." What's your name? I never got your name, Mr. Talk Show host here. Your name? What's your name?
Ben.
Ben?
Yeah.
Okay, hey, Ben. What it is like you just say, Ben just says, "I, in my case, am now present in court." And that's all you say. And the judge will say, "Well, you're going to represent yourself. I, Ben, in my case, am now present in court. I'm now here before the court." And you just say the same thing 3 times. I'm going to ask you 3 times. I swear to God, it's true. They do it 3 times. And then they say, "Okay, we understand." That's all you say. "I, Ben, in my case, am now before the court. I present my case to the court." There you go.
And what does that do? Let me ask you that. I mean, I understand what you said there, but exactly what does that accomplish when you say that? What does the judge understand?
The judge understands that there is a man present in court, and that the man is moving under the common law, and that there is no attorney present. You're not pro se. You're not some crazy jury jurist, whatever. You're not any of this crazy nonsense. So the judge realizes that now you're evoking the common law.
Understand.
You in your case, your suitcase, you're packing all your evidence and notices and everything else. You're packing everything into the court, and you just want the court to take notice that it's a man present in court with their case, and you have evidence and stuff. But like I said, the best way to do it is, like I said, Mr. Cherry, I give credit where credit is due, just like they did with Billy Thornton a little while ago. And that's where you guys could find him on Angela's old talk shows. His name is Clayton Cherry, and he just asks the first question you say to the judge. Say to the judge, "Your Honor, is it not true that for any statement to be deemed admissible evidence, it has to be under oath of affirmation?" And, of course, the judge is going to have to say yes. And then you say, "Therefore, before we proceed, it is my wish," because only man can wish, "to be sworn in through affirmation. Therefore, there can be admissible evidence pressed upon the record in the event of and for appellate review if it is necessary. And it is my wish that the other side do the same." So there you go. And so right there, you done it. You neutralize the other side. There's nothing that they can say.
I have a question.
Unless you're going against another man, then you're in trouble. It's really simple. And like I said, this is great. This knocks all the lawyers out of the picture. This stuff that I'm saying will not work in common law when it's a common law contract between man and man. This is not a loophole to get out of that, because this only deals with administrative government officers coming at you, or attorneys coming at you for credit card companies. Or she did it with a credit card company, worked fantastic for her. She did it with a real estate company, worked fantastic for her. It just knocks the other side right out of the box. There's nobody who's going to show up on the other side.
I have another question. Is that a remedy for a wrongful foreclosure in a federal district court?
Well, wrongful foreclosure, like I said, this is what Clayton Cherry...
No, well, hey, it wouldn't be, because if you took it to federal district court, it would be you taking that claim to federal district court. So the application of this would be if an attorney was bringing a claim against you without having a real party of interest. The real party of interest is only the party that can testify against you. So the attorney can't run any type of claim against anybody. They have to have the real party of interest there to move the court.
And what's good,
but if all that is passed, is there still a remedy if the judgment for foreclosure has already been issued with using this?
That's an easy one. Who made the motion? Who motioned to court for the judgment of the foreclosure? The other side?
Yes, plaintiff attorney.
Everybody knows this one. I've been saying it like a broken record. Who did I get this from? Richard Cornsforth. Everybody knows Richard Cornsforth, right, Ben?
Yep.
Yeah.
Okay, great. What's the case he uses that works like a champ all the time? Gets rid of 99 summary judgments against everybody, against the man, when it comes from an attorney? Trenzi versus Pagliaro, 1965. That's the one that voids every single judgment that's ever been moved, either by a motion or summary judgment by an attorney. 99% of every single judgment is void on its face. If it was only, if the court took notice of an attorney's motion for a summary judgment. Because only a man can motion the court, not an attorney.
Huh. Okay.
Listen to Richard Cornforth's thing. It's a really long, boring thing. It's like secrets of the legal industry. There is a transcript out there on Scribd, like SCRIB. So when somebody says, "Oh man, a guy goes on for hours," talking about silly stuff, it's like, look, there is a transcript on Scribd. You just go on the Scribd website and you type in Richard Cornforth. I even posted it. I took the transcript and I posted it to my account on Scribd. So when people say, "Oh man, he talks on for hours," it's like, look, there's a very simple line. If you go into that Trenzi versus Pagliaro, and it simply says, if an attorney motioned to court for a summary judgment or default judgment is void on its face. It's that simple.
Now, do you take that back into the original court, or do you take it to an appellate court and
Nope, don't ever go to
after the fact?
Nope, you just go in, and every case could be overturned. It's so funny. If you hold common law court, like somebody who's so hassling me like guest number 10, "Hi, ma'am," "Hi, sir," that's okay. I like when people bash me on those bubbles or bash me on the calls. That's fine. I like it. I'm from New York. I'm a glutton for punishment. So if you understand that you're a man, and if you understand common law, if you read the Judiciary Act, oh boy, the lawyers are going to hate this one if they hear me saying this one. If you read the Judiciary Act of 1793, Clause 31, if you did wrong, there's no statutory limitations on when you could bring back your claim or void or overturn a claim if you believe you were defrauded or an attorney brought a motion for summary judgment. There is no time limit on a man. Not only does that Clause 31 say that in that act, your children can bring it up. Their children can bring it up. Their children's children's children can bring it up. So when you hear these statute of limitation nonsense, and like I hear some stupid show, A Handle on the Law, and he always says, "Oh, 2 years went by. Oh, 3 years went by. Oh, 7 years went by. Oh, 15 years went by. That's too long." Bull. In common law, there's no such thing as a statutory limitation because that's called a latch. Man can't be latched. Man isn't bound. Man has will, and he can do whatever he wants at any time he wants. They can't create a way to bound us. It's like everybody knows. What is that one? Article 6 of the Constitution, Clause 2 and 3. Everybody knows that all state and federal employees and judges are bound by their oaths to the Constitution. Well, we're not bound to anything. We're not latched to anything. So when you hear the statute of limitations binds us or limits us, no. It binds attorneys, and it binds like the judges, but it doesn't bind man. Nothing bounds man. Man is like a representative of God on this earth. Nothing bounds man. So the nature of the party is man. Once the court realizes there's a man present, they know that they're talking to their superior. Man has created the court. Man created the legal system. I'm just a representative of my great-great-grandfather who created you, dude. And they realize.
Wouldn't that simply be either a writ of error or a void judgment then?
That's what's great. You see, you're thinking good. But what you got to do is you say compare that with a void judgment or compare that with, what was the other thing you said?
Writ of error.
Right, because that's it. Dean Clifford really liked one. I don't know if you heard me talking to Dean one day on his show. Dean said, lovely. I said, Dean, I watch your videos. I said, you're good. You're going to go places. I said, but you got to control your little temper thing you got going on. But let me toss you a little nugget here. What you're doing and where you're going to fail I said, because when you start stealing, theft, intellectual property, when you start relying upon their codes, their words, their terms of art, that's theft. All that stuff that you're using is copyrighted material. You can't use that in common law. See those legal terms coming across your paperwork, they're going to immediately take you over to the civil side, because if you're a citizen, you could use statutes and you're a big member of their family and you could get away with using their stuff. But if you're saying you're an alien and you have unalienable rights and you're not part of them and you're foreign to them and you use their intellectual property, they're going to charge you with a crime. I said, so instead of charging you with a crime, they move you over to the civil side to protect you from yourself. So when you use words like writ of error, that's like a legalese term in art. So when you say, I believe I've been done wrong, or I believe, of course a writ just means to write, or it means an order, a writ of error. Say, I order that something was done in error. So what you could say is, I order, something was done, and you have to word it like in the common terms, like the common layman terms, like an error occurred. Compare that with writ of error. And then you put it in a four-corner bracket because you don't want that to actually be officially in your paper, but use that little like CF. Compare that with writ of error. So you don't use their terminology, because then if you speak legalese, they could speak legalese. You always want to keep it in the common language of wherever your custom native is, your Peyote people or whatever. You don't want to start speaking legalese. You want to stick it in your native language, the common plain language. You don't want to start thinking fancy and using big fancy words and big. Like I said, I'll send you my one-page lawsuit. You say, "Holy cow, this is so simple, it's scary," because you keep it in simple, plain language. Because you flatly saying to the judge anytime they talk to you and you put it in writing, say, "I don't speak legalese. I don't know what this code 73256 is. This is some sort of crazy code you're coming at me with. Is some man making the claim that I did him wrong? Just give me time to settle this matter on a private side with the man. I'll be more than glad to come back if I don't, but I'm not sure I compensate any man for any wrong that I do to him. Who's saying I did him wrong?" It's like, well, nobody's saying you did him wrong. Well, then you don't have a case against me because I'm the man. I'm on the common law side of the court here now. You got me on the wrong side, and that's, believe it or not, you could Google the word wrong side of the court, and it'll say exactly what I'm saying. It's when they're trying to bring you over to the civil side and you want to get back over to the common law side. You just tell them you got me on the wrong side of the court. It kind of sounds too simple as the wrong side of the court, but actually that is a legal term, so you got to be careful. You could say, "Can you just get me back over to my court?" And then you could do that full corner thing. So I'm on the wrong side of the court. You got me on the wrong side of the court. So you just get back into your original jurisdiction. It's called consuance. I'm trying to how to spell that. CONSUANCE. You're making a claim of consuance. Just saying somebody, like you heard, like you described me, somebody took my personal injury claim and they converted it over to a civil rights complaint. And I just was going like, hey, I filed a claim of consuance. You got it on the wrong side of the court. I demand that you bring it back over to the common law side in which I filed it through the clerk of the court's office. Nobody had the right to practice law and represent me and convert my claim over to a complaint. So you file a claim of consuance. And all consuance means is what I described. Somehow this got over to the wrong side of the court. Can you please bring it over, back over to the side where it belongs?